Prince Andrew's appeal to dismiss sex abuse charges is denied. The decision by a court to deny Prince Andrew's request to have a sexual assault case dismissed is terrible news for the royal family. This doesn't mean that Virginia Giuffre's civil complaint against him will be successful, nor does it significantly improve the possibility that it will be heard by a jury. Let's take a look at the case's latest developments and see what's in store for us in the future. Jeffrey Epstein and Ghislaine Maxwell organized sexual contacts with Prince Andrew beginning when she was 17, according to a lawsuit filed by Ms Giuffre last year. Earlier this week, a judge ruled on a motion to dismiss the lawsuit. The Duke's attorneys argued that the action should be dismissed immediately, at an incredibly early stage, rather than addressing the veracity of the charges before U.S. District Judge Louis Kaplan. When Ms Giuffre agreed to a $500,000 United States dollars settlement with Epstein in 2009, they said she had agreed to a waiver of her ability to sue other prospective defendants. A New York state legislation that temporarily suspended the customary statute of limitations for victims of childhood sexual assault was also questioned by the plaintiff's attorneys. It was a foregone conclusion that the decision would be rendered. Most of the arguments advanced by Prince Andrew's legal team were knocked down by Judge Kaplan, who decided last week in Prince Andrew's favor. There is a lot more material to cover before the matter goes to trial, as the judge's judgment only addressed a few preliminary problems. Lawyers for the Duke of York have the option of appealing the decision. They'll be able to make various arguments to have the case thrown out. There will be a series of depositions, in which attorneys will have the opportunity to examine witnesses who may be called to testify at a later date if the case moves forward. However, unlike Ms Giuffre, who has taken several depositions in cases against Maxwell and others, the Duke has never been cross-examined on the topic. According to what they've discovered in the course of the evidence exchange, defense attorneys often want to throw out the case. To assist attorneys better comprehending trial risks, the judge next issues a series of judgments from his or her bench. Pre-trial hearings allow attorneys to evaluate their odds of winning a case in front of an impartial jury by determining what evidence may be presented. For now, the prince has an incentive to settle the matter swiftly rather than allow the counsel for Ms Giuffre to interrogate him on oath, which may cause him issues in the future. Last year, federal prosecutors in New York sought criminal perjury charges against Maxwell based on 2 depositions she gave in a case launched by Ms Giuffre against her in 2016. Last month, she was found guilty of sex trafficking and conspiracy, but she has yet to be tried for lying to the FBI. In addition, Prince Andrew is likely to be under tremendous pressure to resolve the matter in order to prevent spectacular headlines that might harm the royal family's image. A settlement may be perceived as more expensive than the unfavorable publicity created by the litigation. An agreement of this kind is unlikely to result in an admission of guilt or responsibility on anyone's part. Most civil lawsuits in the United States end in settlement, barring a complete dismissal. Epstein and Harvey Weinstein, a prominent movie mogul, are the targets of several women's harassment claims. So yet, none of these cases has gone to trial.